To determine who is liable on a negotiable instrument and to whom, we must first understand the obligations one incurs by becoming a party to a negotiable instrument. Imagine a law student borrowed money from a lender and executed a promissory note payable to the lender. If the lender later negotiated the note to a third-party financial institution, what was the law student's liability on the note? Subject to some nuance, the maker of a note must pay the note according to its terms when it was issued. Unless stated otherwise, this liability attaches without the need for any prior notice or demand and flows to any party entitled to enforce the instrument. In our example, the law student was the note's maker, and the financial institution became entitled to enforce the instrument through negotiation. Thus, the law student was required to pay the note to the financial institution according to its terms at issuance. A drawer's obligations are a bit more complicated. If the instrument is a cashier's check, the drawer's obligations are the same as a maker's. That is, the drawer must pay the check according to its terms at issuance. As you may recall from another lesson, in the case of a cashier's check, the bank's customer, also known as the remitter, isn't a party to the instrument. Instead, the bank issues the check against its own funds. Thus, it is the issuing bank that is liable to pay the instrument to the check's payee. If the instrument is a draft other than a cashier's check, then the drawer's specific obligations depend on whether the draft has been accepted or dishonored. Let's use an example to illustrate these obligations. Imagine a law student ran a side hustle growing and selling premium herbs for $100 an ounce. An herb enthusiast bought 2 ounces of herbs and wrote the law student a check for $200. If, upon presentment, the drawee bank dishonored the check, could the law student bring a claim against the herb enthusiast to collect the $200?